What if your daughter's husband convinces her she deserves more of the inheritance? What if that vacation home you thought would bring the family together becomes the reason your kids stop talking forever? This isn't hypothetical. It's the nightmare scenario that tears families apart. Siblings hiring lawyers, heirlooms sold for legal fees, and grandkids caught in a war that lasts years. And here's what's really scary. This happens to families with millions of dollars and top-tier estate attorneys. Today, I'll show you how to define what fair really means for your family, strategies to prevent inheritance wars before they start, and the tactical tools professionals use to make sure everyone feels treated fairly, even when they don't get the same thing. Quick note before we dive in. I'm a fiduciary financial advisor, not an attorney. This video is educational, so please talk to your estate planning attorney before making any decisions. Let me tell you about Aretha Franklin's family. The Queen of Soul died in 2018. And you would think someone that successful would have had everything perfectly planned out. But here's what actually happened. Her family discovered not one, but two handwritten wills. One from 2010, found locked in a cabinet. Another from 2014, stuffed in couch cushions. These two pieces of paper pitted three of her sons against the fourth in a legal battle that dragged on for 5 years, until a jury finally decided in 2023 that the couch note ruled. 5 years of a family torn apart over pieces of paper. But here's what really happens in most family inheritance battles. It follows a predictable pattern. Phase 1, the first 3 months after death. Everyone is in shock. They say, we'll work it out as a family. Phase 2, month 3 through 12. That's when the surprises get discovered. Maybe dad changed his will after his dementia diagnosis. Maybe the lake house that everyone assumed would be shared equally is now going to just one sibling. Resentment starts building. Phase 3, 12 to 36 months, formal lawsuits, asset freezes, spiraling legal fees. And here's what makes this even more heartbreaking. These disputes rarely end up well for anyone involved. Even when families try to work things out through conversation, the emotional wounds often run too deep by this point. So what triggers these family wars? It's actually not about the money itself. First, unequal sentimental assets. When one child gets the family lake house and another gets an equivalent dollar amount in stocks, it feels like favoritism, even when the values match perfectly. That lake house carries memories. The stock portfolio doesn't. Second, surprise allocations. Children discover changes made when parents were maybe not thinking clearly or spouses influence decisions at the last minute. Third, and this is a big one, the spouses. Sons-in-laws and daughters-in-laws often become the outside voice urging a fight. They are the ones saying, don't let your brother steal your share. Or, we need that money for our kids' college. They amplify the fairness narratives because they have their own household goals. And fourth, ambiguous instructions. When parents write things like divide fairly among my children, they think they are being helpful. But they are actually creating a lawsuit waiting to happen because everyone has a different definition of fair. The hidden cost isn't just the legal fees. Estrangement can last decades. Therapists see prolonged grief in these families because instead of mourning their parents together, siblings are locked in combat. Grandchildren grow up not knowing their cousins. Holiday traditions die. So how do we decide what's fair in the first place? Here's the fundamental truth most families never discuss. Treating everyone exactly the same often creates more problems than it solves, because fair isn't always equal. Think of it like this. Trying to treat unequal circumstances equally is like giving every child the same size shoes. It only fits if they all have the same needs. Now, consider this scenario. You have 2 adult children. One daughter moved back home to take care of you for 4 years, giving up her career to be your caregiver. Your son lives across the country, visits twice a year, and he built a successful business and doesn't need financial help. Is giving them each exactly 50% of your estate really fair? Or would fair mean recognizing that your daughter sacrificed $240,000 in lost income over those 4 years to care for you? Here's the framework I recommend to families. Consider 3 factors: needs, contributions, and equal baseline. You might decide needs matter most or weigh contributions heavily. There is no one-size-fits-all, just what aligns with your family's values. For example, Maybe one child has special needs and will always require support. Maybe another is a single parent struggling financially while their sibling is a successful doctor. Or perhaps one child helped build a family business while others pursue different careers. The key is defining what fair means for your family before you create the plan. Not your neighbor's family, not what worked for your families, your family. Here's the question every parent should ask themselves. If I explained my inheritance plan in a letter today, which child would object and why? If you can't answer that question, you are not ready to finalize anything yet. Now, if you are trying to figure out what fair really looks like for your family, we can help. Every situation is different, and the right strategy depends on your goals, your relationships, and what you want your legacy to reflect. Feel free to reach out if you want to talk it through. No pitch, just a thoughtful conversation about what makes sense for your family. The link is in the description. Okay, so once you've defined what fair looks like, what types of tools do estate planning professionals use to implement it? Let me walk you through some common strategies that can make unequal feel fair and prevent those family wars we talked about. First, life insurance offsets. Here's how this works in practice. Let's say you own a vacation home worth $1 million that you want to leave to your daughter because she's the one who actually uses it and maintains it. But you have two other children, and giving her $1 million asset while they get nothing from that category feels unfair. A common approach is working with your financial advisor to price a second-to-die life insurance policy, then coordinating with your estate attorney so the ownership and beneficiaries are set up correctly. Now, when you pass away, your daughter gets the vacation home. Your other kids each get $500,000 from the life insurance, and everyone feels treated fairly. The premium for a healthy 65-year-old couple, often less than $10,000 per year. Second, LLC buy-sell agreements. This is perfect for illiquid assets that are hard to divide. Many families have their advisor model the pros and cons of an LLC and then ask their attorney to create and fund it if the numbers make sense. The operating agreement might give siblings a right to sell or buy it at a formula you all agreed on. The funding comes from the life insurance or installment payments. This approach works well when your heirs have different liquidity needs. One might want to keep the cabin, another might need the cash. Third, staggered trusts. Some parents ask their estate lawyer about staggered trusts that might, for example, release 1/3 at age 30, 1/3 at age 35, and the final third at age 40. This keeps parity in how assets grow over time and can help protect inheritances from divorces or creditor claims during those vulnerable early adult years. Some families also explore trusts with differentiated terms, where attorneys might structure different levels of control or access based on each child's circumstances. This approach lets families be fair by addressing what each child needs rather than providing identical treatment. Fourth, and this is simple but powerful, a statement of intent letter. This is a non-binding memo written in plain English that explains your reasoning. For example, we left the house to Emily because she lives nearby and has cared for us for years. We equalized John's and Mark's share with the life insurance so no one feels shortchanged. This minimizes shock, reduces the chances of successful contests, and gives the probate judge context if disputes arise. It's not legally binding, but it's emotionally powerful. These strategies work best when matched to your specific assets and family situation. For business interests, attorneys might recommend voting versus non-voting stock splits combined with insurance. For real estate, LLCs with usage agreements often work well. For marketable securities, those are usually easier to divide outright or through mathematical formulas. But here's the thing. Even the most brilliant equalization strategy will fail if your family doesn't understand it or feels blindsided by it. So when should you have the conversation? While everyone is healthy and before any documents are signed. And please, not at Thanksgiving dinner. Holiday emotions run too high. Aim for a calm, off-holiday family meeting, maybe even a professional facilitated Zoom call. Now, I know what you are thinking. Parents often avoid this talk because it feels morbid or distrustful, but silence is actually riskier. When families don't discuss inheritance plans, that's when surprises happen and resentment builds. So how do you bring it up without making it weird? Use an external trigger. Say something like, our financial advisor suggested we have an annual family legacy check-in, so nothing is left vague or unclear. This makes it procedural, not personal. The best time to plan was 20 years ago. The second best time? Today, before surprises force your family into reactive mode. Now, how detailed should you get? Share your rationale and framework, but you don't necessarily need to reveal exact dollar figures. unless you are comfortable doing so. The key is emphasizing your process. Say things like, "We hired an independent business appraiser to show you are being objective, not playing favorites." What extra documentation should you consider beyond the standard legal documents? Video messages explaining your choices can add an emotional component, but make sure to check with your attorney whether they are recognized in your state. Family mission statements or charters work especially well for blended families. After we've mapped out the plan, I typically suggest that clients ask their attorney whether mediation and no contest clauses would strengthen it. What if one of your children disagrees with the plan? In many families, a neutral mediator can help, and no contest clause, if allowed in your state, may reduce challenges. But its effect depends on local law, so discuss this with your attorney. The goal isn't to get everyone to love every decision. The goal is to get them to understand your reasoning and feel like they were heard and considered. Here's what I want you to remember from today. Fair isn't automatically equal, but it can be explained and implemented if you do three things. First, define what fair means for your family by weighing in needs, contributions, and equal treatment based on your values. Second, document that intent clearly and communicate it while you are still here to explain your reasoning. Third, use these specialized tools we discussed to make fair feel friction-free in practice. Your legacy isn't just the money you leave behind. It's whether your family stays together or falls apart after you're gone. Don't let poor planning turn your life's work into your family's destruction. You've now got the blueprint for a fair inheritance plan. But even the perfect plan can fall apart if the wrong person is in charge. The number one mistake families make when choosing a trustee can undo everything we just discussed. Tap this video next to learn what that mistake is and how to avoid it, because picking the right person to execute your plan might be more important than the plan itself.